Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be tenants threatening habitability and discrimination lawsuits. Well, hello, everybody. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. The song today was The Sound of Silence by Simon and Garfunkel that was originally released in 1964. And I thought it was a apropos song because we really want the sounds of silence coming from our building as opposed to what we can normally get with tenants that are creating all kinds of havoc. Let's go into the ground rules for the show, and that is that it always starts with an opening topic. And then after the opening topic, those people that are in the Zoom meeting will be able to ask me questions if they electronically raise your hands. And in fact, if you are in the Zoom meeting now, please do that now, and you'll have the best chance that I will call on you before the show ends. Also, if you're watching on YouTube, I would please ask that you hit the like button and subscribe to my channel because it really does help me. And with that, we're now going to open it to the topic at hand. And the topic at hand is my tenant is threatening discrimination and habitability lawsuits. Boy, is this a common tactic that is being played against so many landlords. What we have here is tenants attorneys who are just filing these lawsuits either for discrimination or more likely for a habitability, claiming things were wrong with the premises. And this is just a day-to-day occurrence. And I can't tell you how upsetting it is for landlords and whether they're going to have proper insurance to cover it or not, because these cases, every single one goes into the thousands and thousands of dollars. So let's talk about discrimination first. Discrimination in the state of California can legally take many forms. It includes race, gender, sexual orientation, age, disability, and religion. You've got to know what constitutes discrimination, those categories. And it's not just you. It's you and your manager or your agent, because if your agent or manager makes a mistake, guess who's going to get sued? And that's you. So they have to be educated. And the easiest way to educate them is to have rental leasing requirements as part of the application process so that everyone knows what your leasing requirements are, so no one could ever charge you with, quote, discrimination. Now, here are some key points with regard to leasing requirements, and that is put it in writing. Put it in writing as to what your leasing requirements are and attach that writing to either the application that you're handing to them, or if it's a separate page, make them sign it that they received this and give it back to you, an extra one back to you, so that you know that they received it. By the tenant acknowledging that he has the rental leasing requirements, it's much more difficult for them to claim that you are discriminating, because you're giving them what requirements it's going to be necessary in order to gain entrance into my building. Okay? Also, under the new California law, you can't take a credit application fee from a tenant unless you handed them this form. So for reasons of even taking a credit application fee, make sure that you hand them the form. If it's attached to the application, that's fine. If it's a separate form, then make sure that they sign for it. Now, right before the show, and I've done this in the past, I actually created a form and I put it on my website. It's at evict123.com. Go to the free form section, and there's a brand new form there right by the application form that says renting leasing requirements. That's the form that you can either stick to the application or as a separate form, and I do have for the tenant to sign it. So what does this form tell the tenant? Well, it tells the tenant that, hey, we're going to check the credit of anybody who's 18 years of age or older, and that they're going to have to fill out this application form. So every person who's moving into your unit, there could be a few moving into one unit, every person who's over 18 is going to get an application and they're going to have to fill it out. When they fill it out, they're going to have to give you proof of identity. And what does that mean? It means that they have to hand you a driver's license. If they say to you that, under California law, I don't have to show you my driver's license. And that's true, everybody. That is true. You do not have to show the driver's license. But then you can tell them, well, if you don't show me the driver's license, then guess what? I'm not giving you the unit. That's also legal. You also want to see proof of income. So like income statements or maybe bank account statements, but you want to see that the income that he's putting on his application is what he's actually earning. So from bank statements to employee statements, these are the things that you're going to ask for, and that's going to be contained in the renter leasing requirements. Also in the renting leasing requirements, you're going to state that in order to qualify for this unit, that you have to earn at least 2.5 to 3 times the monthly rent, that your income is 2.5 to 3 times the monthly income. You can play with that figure, but we're saying anywhere from 2.5 to 3 times. Okay. And again, we want to conform that you're actually making that. And that's why we're asking for pay stubs, bank statements, tax returns. This is all what's going to be required. And that again is in this rental leasing requirement notice. Now, again, I want to tell you why we're doing this. We're trying to stop baseless claims against discrimination. We're also trying to get a good tenant. So if you follow this, then they can't claim that you discriminated because you didn't meet the criteria of the pre-printed requirements that you got when you got my application. And again, under California law, you can't even charge an application fee unless you first hand them these leasing requirements. Okay. You also want to tell them that their credit will be checked. Okay. A credit check will be conducted on all applicants, and you must have satisfactory credit. If you don't, then that will not be entrance into our building. You won't be accepted. And also, it's not just the credit, it's also other factors such as bankruptcies, outstanding debts, collections, or you've been the subject of lawsuits. I've said in the past that you should, as part of your credit check, you should also check with the county of the Superior Court where the property is located to see if this person has been the subject of a bunch of lawsuits. If you know that he's sued the last 5 landlords, guess what? You don't want this person in your building. So you can either do this lawsuit check through the apartment association, or you can do it yourself if you're handy at looking people up at the county Superior Court. But please do that because that's another criteria. And you're going to tell him that in this requirement for leasing that we're going to be checking your credit, but there's also other types of credit. Now, I suggest that when you get the credit score that you're only going to accept credit scores of 700 or above. And that should be, again, contained in this requirement form, 700 or above. Now, let's talk honesty. It is infinitely better to have a vacant unit than it is to have a tenant occupying the unit who's not paying you rent. That is just a whole bunch of harm. It's going to cost you a minimum of $20,000 nowadays to get rid of a bad tenant because you're probably not going to start the case for a couple of 3 months, right? Then you're going to go to an attorney, such as myself. It's going to take a minimum of 3 months, maybe longer, to evict the tenant. Then you're going to have to rehab the unit because these tenants are very damaging to your unit. So you're going to have to fix it up. Then you're going to have to then put it back on the market and you're going to have to lease it again. You're looking at $20,000. You've got to keep the credit scores high so you'll have an applicant who at least has the ability to pay rent. So right there on that renter's leasing criteria, you're going to say that I need at least 700. Now, You might want to adjust it based on the economics of where your building is located. But again, no one wants to pay $20,000 in losses because you picked the wrong tenant. Okay? All right. Then we're also going to talk about rental history. We want to see a minimum of a 2-year rental history. That's going to be contained again in that statement that you hand to the tenant. And the applicant should show that they've never had a history of evictions or any other lease violations. If you call the other landlord and say, paid his rent on time, place was perfect, but you know what? He blocked the car so other tenants couldn't get in or out. Well, that's lease violations. So you're going to tell him, if I find out about lease violations or evictions, that would be a criteria why you would not get my apartment. Also, and most importantly, you want to tell the tenant that as part of the screening criteria, that I need to see the last 6-month rent payments to your current landlord. I want to see that for the last 6 months that you paid your landlord. If he or she can't produce that, you've got yourself a bad tenant and you don't want to rent to them. And again, this is in your screening criteria. They can't scream discrimination. Well, they can, but they're not going to prevail because they didn't meet your criteria that you handed it to them. Okay? You also want to tell them that you're going to run a background check. You want to see if there's been any criminal activity, specifically relating to property crimes or violent offenses. These would also disqualify them from coming into your unit. You do have to be concerned when these incidents occurred. If they occurred 20, 30 years ago, it's probably not relevant, but something certainly close in time would be relevant of why you would want this person in your building. And then there's another thing. You guys are getting phone calls when you're leasing out your units and you say, hey, do you take Section 8 applicants? If you say the word no, you will be sued for discrimination because in the state of California, you don't have an opportunity to just state, I don't want Section 8 tenants. You have to say the word, of course we do. Of course we do. You have to give them an application. But incredulously, if you do a credit check, which just occurred January 1st of 2024, you can't use poor credit as a means to reject applicants who are Section 8 applicants. This is totally insane, ladies and gentlemen. It now goes on something else called the ability to pay. So we all know that Section 8 deals with subsidized housing. And in my example here, I'll tell you that the apartment is going for $2,200. So more likely than not, the government will pay $2,000, your tenant will pay $200. Well, if the tenant can show the ability to pay $200, then you have to lease to him. You can't use his credit under this crazy California law, which has been in existence now for about 14 months. However, and I've said this before, the way to get around this is make sure that in all of your advertising for leases and also on that form that you're going to give to the tenant, state on it that we only lease month to month only. We only lease month to month. I know everybody wants to do a 1-year lease, but for statewide rent control and also for those properties under the Just Cause ordinance for the city of Los Angeles, you don't want to lease on a 1-year lease. So I would just do it month to month. This way, Section 8 won't accept it, and it's not your problem. Again, that should be contained in the rental leasing requirements document that you gave to them. Okay? All right. You also want to state on that criteria how many members or people can occupy that one unit. Now, fair housing has a rule of thumb, which is 2 per bedroom plus 1. So for a 1-bedroom unit, that would be 3 people that could move in. For a 2-bedroom, that would be 5 people that could move in. Put that criteria on that rental leasing form. Now, if you have a single, you can't limit it to 1 person. That, my friends, would be discrimination. And you're saying, how is that discrimination? I'll let anybody go in. Black, white, blue, I don't care. Well, it's discrimination on the basis that you're prohibiting children from living in your building. Because you see, a child can't rent the unit by himself, so he'd have to come in at least with one parent. So for a single, make sure that your criteria is that there's at least two people that can live into a single unit. Let's move on to the second type of lawsuit that landlords are getting sued left and right on, and these are habitability lawsuits. I can't tell you that, and we handle these when insurance doesn't kick in, but we're getting, my clients are giving 2, 3 of these per week. Landlords are getting sued, and it's just a money grab from these moronic and marauding attorneys who are sitting there looking for anything. You could have the best place in the world, it doesn't matter. And they're going to come back and try to sue you. And the insurance companies, incredulously, are just paying off these claims. And what happens is they either cancel you or your insurance rates go through the sky. There has to be statewide legislation protecting landlords, which of course there never will. But then there's not going to be any affordable housing. You know, if your insurance is $40,000 a year for a 10-unit building, guess who's actually going to be paying for it? So we really have to do something about these habitability lawsuits that are being filed against innocent, and I mean innocent landlords. So how do you protect yourself? It's really a work of art. Let's go over it. The first one is that you want to have regular inspections of your unit and also of the common areas. Walk around, at least go into the unit twice a year now. Serve an access notice you're going in. Inspect the unit. If anything needs to be fixed, fix it. It's really simple. But this way, by going in to the unit and checking, when the tenant is claiming all this stuff, you could say, hey, I was just there on June 1st. I was just there on January 1st. I went in every 6 months to check, and these things didn't exist, okay? And you can even make a chart as to when you went in and what you saw and keep this as your rental records. The next thing is, things are going to go wrong with your unit. Things are going to go wrong with your unit. And when a tenant tells you that something's wrong with your unit, real simple, fix it. When should you fix it? Fix it now. Why do you need to wait a week to call a plumber? You're just trying and begging to get a lawsuit. If something is wrong, call that repair person immediately. I understand about weekend rates, okay? But again, if it's more of an emergency situation and they don't have electricity or they don't have hot water, you better do that immediately, okay? Also, make sure that in your rental agreement, it states that the tenant must provide notices of repairs in writing. Make sure that provision is in your rental agreement. I know it's in my rental agreement, which is free and online in the free form section at evict123.com. If you have an older lease and it doesn't have that in there, I've got a change of terms of notice that is also on the website that will now require tenants to give you in writing, unless it's an emergency, repair request. Now, that form is good as long as it's a month-to-month tenancy. It's good whether it's rent control, non-rent control, I don't care what it is, that's a good form. And use that form because you see, if in fact the tenant is claiming he's told you all these things, you know, and all of a sudden you get this magic lawsuit, well, you can show that he never gave you anything in writing and that was a term of the lease. It'll blow his case out of the water, okay? So either it's in your rental agreement or use a change of terms of tenancy for anything that is where there's only a month-to-month tenancy. Let's move on. You want to document all tenant issues. Have a little journal. The tenant asked me to fix the garbage disposal on this date. I fixed it on this date. Okay. I would also send a letter to the tenant every time there's an interaction dealing with a repair and saying, you asked me to fix the garbage disposal on Tuesday. I fixed it on Thursday. Thank you very much for informing me of the problems with any unit because we want to take care of it immediately. Send that letter out. Keep that letter in your file. If you've got good documentation, you can blow these marauding attorneys out the window. Now, if you've made a repair, you got a receipt. Keep the receipt, okay? Keep it forever, or at least for at least 2 years after the tenant is moved out of your building. Keep these receipts as part of the journal. of all the work you did in his unit, all of his repair requests, and all of your documentation. Also, when you're leasing out a unit, and this is now the law as of July 1st, 2025, take pictures of the unit so you can see the condition of the unit that I gave to him. Look at how it looked, ladies and gentlemen of the jury. This is what it looks like now. Who do you think created the problem? Take pictures of a unit before you're leasing it out, and also take pictures when you did the repair. I know my people do that. I have a handyman who works for one of my buildings. He takes a picture before and after the repair was made. Keep that. Hey, you can see that the latch was off on the cabinet. He takes a picture before, he takes a picture after, and then of course he sends me a bill, which of course I have to pay it. But I have this documented, okay? Also, you want to familiar yourself with the local laws and what your requirements are for those jurisdictions. And they're so varied. I can't go over them now, but from Los Angeles to Culver City to Santa Monica to Long Beach, there is a plethora of laws. Make sure that you're aware of them. For example, and I had this case just today when I was at the office of somebody who leased out an illegal unit. If you lease out an illegal unit in Los Angeles, for example, the tenant has no obligation to pay rent, and you have to pay that tenant thousands and thousands of dollars in relocation costs. So know what the law is. And by the way, for illegal units, you can make them legal. It's a law by the state of California. You got to hire a contractor, but the local municipality like Los Angeles is forced to legalize those units. So please do that. Also, and I know so many people do this, and it's in most jurisdictions, it's against the law. It deals with short-term rentals such as Airbnb. Los Angeles has a home sharing law, which requires you to get a license. It requires that you live in that unit. Yes, live in that unit for at least 2/3 of the year and only lease it out for 1/3 of the year. So please don't do these short-term rentals. I know make sure that you know the law for the jurisdiction where your property is located. And the last one, which so many of my clients do, and it's not really legal specifically in Los Angeles, is renting rooms. It's considered a boarding house. You don't have a license, and the tenant can demand relocation and doesn't have to even pay rent because it's an illegal tenancy. So that's the dealings with regard to habitability. The last thing with regard to habitability and also with discrimination is review your insurance policy. I know that's a sore subject because you don't even want to think about insurance in this state based on the crazies who run our state. But review your insurance policy to see whether you're going to be covered for habitability claims, to see if you're going to be covered for discrimination claims, because hiring an attorney for these types of cases is really no fun. And with that, we're going to open it up to questions and answers, ladies and gentlemen. And this broadcast, you know, is only for informational purposes only. If you do want to talk to me electronically, raise your hand. I see we have a few people have already done that. This broadcast is for general questions only. If you have a case with my office, please save that specific question by calling my office, and God knows I'll be there on Monday. And last, if you are talking to me, please keep your camera open because it's much more enjoyable for those people watching the broadcast. And once again, if you are on YouTube, please hit that like button and subscribe to my channel. We're now going to open up to an old favorite. Is he old? I don't know. And that is Jim Polina. Say hello.
Hey, Dennis. I'm old enough to keep playing basketball.
That's good.
Okay, a couple questions. You just barely hit on this. Renting the rooms is a boarding house. So if I wanted to rent a 3 or 4 bedroom house out to 3 or 4 individuals, not each person is individually responsible for their rent, not cumulatively. Is that a boarding house?
Technically it is, but it's based on the definition in your jurisdiction. Like, for example, in Los Angeles, one person is not, maybe two, but there's kind of a gray area in the law of what they're claiming to be a boarding house. So I know your property is not in Los Angeles. It's
Right.
probably okay, but you need to check with that local jurisdiction.
Okay. Now, I'm getting to that point where I may need to hire a caregiver to live with my mother. Um, so we're paying her, obviously, and she's living in the house full time. Is that a tenant?
No, that would be an employee because that person's not paying rent and
Okay.
therefore is just an agent. So they don't have any quote tenants' rights. And under the Code of Civil Procedure, Section 1161, subsection 1, you would just fire that caregiver and then serve that person with a 3-day notice to quit. You might want to do up a little employment agreement and have an employment attorney check it out so that you don't run afoul of employment laws, which my firm does not do. But also, it should also show that upon termination, you have, 3 days or 7 days to vacate the premises.
And if they don't vacate, eviction?
It is an eviction, my friend.
Okay. All right. Thank you, Dennis.
And thank you, Jim. We are moving on to Danielle Moskovitz. Say hello, please.
Hi, thank you.
Hello.
Thank you, Dennis. So I have a difficult tenant who, thank goodness, is vacating the property. They were provided a 2-week notice for the walkthrough. They refused, and I provided them a 48-hour notice for the landlord to go through the property, and they prohibited me from entering, and they refused showing. Is there anything that can be done contractually in the future for future tenants that I can include in my agreement to prohibit this type of action?
Well, the pre-inspection for the security deposit that a tenant is entitled to is their rights. It's not your rights. So the law gives the tenant a chance to be told by the landlord, hey, I'm going to deduct for this item, I'm going to deduct for this item, but you haven't moved out yet. If you want to fix it on your own, feel free. And this way I won't take it from your security deposit. So that's a right of the tenant. It's not a right of the landlord. And quite frankly, if the tenant says, nope, I don't want you in here, great. Then in that situation, you're just going to do your normal security deposit itemization by checking the unit after the tenant vacates. With regard to that, the tenant failed to allow a showing to prospective new tenants. I guess you could have a phrase in your contract that says if you fail to allow access for showing to new tenants, prospective tenants, then for each time you fail, there's $100 fine. I don't see a problem with that if it's contained in your rental agreement.
Okay, great. Just second question. What is the penalty for in RSO property in Los Angeles? It's required that you provide with the agreement, the rental, any increase, that you provide the certificate allowing you to rent the apartment. The question with the LAHD, what happens if the landlord does not provide that certificate showing that it's a legitimate rental property?
If your property is located in the city of Los Angeles, it's either going to be subject to the rent stabilization ordinance or the just cause ordinance. In either case, you're going to have to register your unit. You're going to get a registration certificate with the year stamped on it, like 2025. That registration certificate needs to be mailed or given to each unit. Now, what happens if you don't do it? If you don't serve that notice on your tenant, then if you serve a 3-day notice because the tenant hasn't paid the rent for the last 6 months, technically you will lose your case because you cannot demand rent until you first serve the notice. Now, once you serve the notice, even if you did it late, then you can go back and ask for any rent that's owed in your 3-day notice. But if you serve that 3-day notice, you got to make sure that the tenant has that current registration certificate.
Got it. Thank you.
All right, good questions. Moving along to Margaret O'Brien on a Saturday.
Hello.
Hello.
I have a question regarding can I pass on um, uh, costs for improvements. I have a unit right now. I'm spending something like $8,000 for a new wall heater, for new flooring, for a new kitchen countertop. So how it's a rent controlled unit. Is there some I can pass on part of this?
Do you have a tenant in possession right now to the unit where you're making this, or is it vacant?
Yes, a tenant is in possession, has been there for 20 years.
Only 20?
Yes, I have
Okay.
some for 35. I
Well, you're not lucky, especially if you're under rent control, because the rent is
am
probably
under
very.
rent control.
I'm saying you're not lucky because your property's under
I
rent control.
know I'm not lucky. I know
Okay.
that.
You can apply to the city for a capital improvement. If they
Uh-huh.
grant it, then you can offset 50% of the cost of that capital improvement to the tenant, but it's amortized over 5 years.
Okay.
So you could
Uh,
file with the city a request for a capital improvement. You show them all your bills. If they grant it, then that tenant would be responsible for paying 50% amortized over 5 years.
okay. And where do I to my property is in San Pedro. Do I go to where do I go?
Well, it would be the Los Angeles Housing Department. San Pedro, in case you guys don't know this, is really part of the city of Los Angeles, just like Winnetka is, just like Hollywood is, and just like Encino is. It's really all part of the city of Los Angeles. So you want to go to the closest Los Angeles Housing Department, or you could call them up and, you could wait about 48 hours for them to come to the phone.
Yes.
Or you can go down there, or you might be able to get these forms online.
Okay. Thank you
Thank,
very much.
thank you, Margaret. And moving along to Austin, how are you today, sir?
Hey, I'm doing pretty good, Dennis. Thank you for another edition of Landlord Tenant Talk Radio today. So my question, I am owner occupying a fourplex in the city of Long Beach, and I'm getting a lot of requests. So it's two single family houses and a duplex on the same lot, and I'm living in one of the single family houses, and I want to rent a room. I have it listed for single occupancy only, but I'm getting a lot of requests from like single moms or single dads, and I'm just like, no, I don't want to deal with this. This is single occupancy only. Am I okay to discriminate that way?
This is one of the few ways that a landlord can discriminate. So, for example, let's pretend you are Persian and you only want a Persian person to move in. And you're female, so you only want a female Persian to move in. This is one of the few laws in the state of California that you can ignore discrimination because they're living with you. So you get to choose the ethnicity and the gender of the person coming in. So you certainly can limit it to one person.
Awesome. Thank you. Real quick, another question that came up with the CARES Act. If you have a federally backed loan on a property, when you serve a hybrid 3/30 day notice, you got to give them 30 days to move out. Well, I keep hearing that the Trump administration wants to take Fannie and Freddie private again because they've been under because like 16 years ago they used to be privatized. If that does happen, will that 30-day move out requirement go away?
It will go away, but it should also go away because the CARES Act was started during the COVID time. And they had one provision which was sunsetted, which means that it expired by its own expiration date. But somehow they just forgot this. This is total insanity that if you have a federal backed loan or if you have even one Section 8 tenant in your building, you have to serve them with this CARES Act information and that special hybrid notice to pay rent or quit, which is a 3-day notice to pay or 30-day notice to quit. The Trump administration should just wipe that off the books since it doesn't make any sense now that last time I checked, COVID is over.
Could he do that through executive order?
I believe he could, yes.
Awesome. Thank you, Dennis.
However, if he does do it through executive order, there'll be 14 judges lined up. And that's another topic for another show, but that insanity has to stop. And you know who would agree with me? I would bet that Janice would agree with me. Say hello, Janice.
Hi, Dennis. I would agree with you, except that I think executive orders have a finite period of time, do they not?
They do.
Yeah, that's what I thought. Two quick questions. One, I was listening to one of these companies that offers tenant credit being added to their, credit scores. They said that if you're exempt from doing that as a landlord, you don't have to include that exemption in the lease. Is that true?
I'm not exactly sure what you're referring to.
Where tenants have the option, I think for a fee, $10 a month, to have their rent payments
Oh,
improve their credit scores.
yeah, you can't, no, that you can't waive that. What we're talking about is a law that's going to be effective as of April. And that is, in fact, that paragraph is in my rental agreement where the tenant has the option to state that, hey, I want you to report my positive rent payments to a credit institution. I know I'm going to have to pay for it up to $10 or what it actually costs. So if the tenant in writing tells you that, and you have to actually give it to them in writing, or it's part of any new tenancy that is created, it should be contained in the rental agreement, or as of April 1st, technically you're supposed to send them this contract, giving them the opportunity to report positive credit to these institutions. But most tenants, I don't think, are going to want to do this. But if a tenant does, then you're forced to do it, and you're not getting reimbursed for your labor. You're only getting reimbursed for the cost of doing this. I know the Apartment Owners Association has a system already in place for that.
But I'm exempt under that law because I'm a single family
Yes,
unincorporated.
that would be exempt, correct.
Okay. And so they don't have to be
That's
told.
only for 15 or more units. I should have
Right.
stated that.
Right.
So if you're
And
less than that,
yeah, my second question is, I was reading, probably not a good idea, but I was reading the San Francisco Tenant Union requirements for owner move-in. And it said that you had to give people with disabilities, and people who have emotional support animals, who I guess are considered people with disabilities of some kind, a year notice, for an owner move-in. Can that be true, or is that just San Francisco?
well, that's true for, I know, an Ellis Act eviction. If you're over 62 or disabled, you have to give a 1 year's notice. So that wouldn't surprise me at all.
But that includes people with emotional support animals?
Well, but if you have emotional support animal, you've got some, Dr. Guggenheim who's stated that this person has a disability and requires the services of an emotional support animal.
So it's a year notice in California?
If that, you read it, I'm sure it's true.
That's what it said, but I
Yeah.
thought that,
But that's also true for if you're going to do an Ellis Act eviction here in the Southern California area. If they're handicapped or a over 62, you have to give 1 year's notice. They can opt for that.
So that I just strikes me as unbelievable, but I guess it shouldn't be unbelievable. Thanks a lot.
Janice, where is your property located? In what state?
Placer County.
What state?
Oh, well, yeah, California, followed closely by
So
New York for crazy laws, but
you got it.
yeah.
And anyway, thank you very much. We are moving on to Alex. How are you? Mr. Alex, are you there?
Dennis,
Are you there? Try it one more time because I hit the button by mistake. Alex, say hello. Oh, there you go. Say hello.
okay, hello?
Yes, go ahead, sir.
Okay, there we go. All right. So, I'm trying to find the picture so I can ask the question correctly. Sorry, it involved the topic you brought up about Section 8. The sorry, hold on. I'm looking for it. I apologize. If you want, come back to me and oh, here we go. Sorry. Disparate impact with regards to Section 8, that there was lawsuits going out because it was discriminating against Section 8 with the month-to-month tenancy. What are your opinions on that, or have you you know, have to
I haven't
defend
heard
that?
that. I don't think it's discrimination because, but anybody can sue anybody for any reason, but I don't think it's consideration because I only lease to everyone month-to-month tenancies. That's
Got
my
it.
business model. So you can't tell me I'm discriminating because I do it to anybody and everybody who wants to lease to me. So I can't see that as discrimination, but anybody can bring any lawsuit against anybody.
Got it. Okay. Thank you.
Thank you, Alex. Okay, let's see. We are moving on to Pamela. How are you?
Unmute. Okay, sorry, first time. First of all, thank you for all of this. I've acted a lot smarter by listening to your classes. I'm a real estate agent, and a lot of my clients fall under the new just cause bucket where it's a condo or a single family home that I've assisted them in renting out. My question to you is this new ordinance where they have to now register the just cause. You had mentioned that you need a statement number, but they're only sending out the statement numbers if the mailing address and the site address are different. So for all those people that have been renting, this is their first time being a landlord and their address is still the same. How do they get registered so the tenancy that they currently have in place is now protected?
Legislative boondoggle. That's what we have here. All I can tell you is that you need to, I would send an email to the Los Angeles Housing Department or try to call them. And I mentioned on a previous broadcast, a client said that when he got on the line and was on hold, it said, "You are the 542nd caller," believe it or not. So, um, I would send them an email and say, "Hey, I'm leasing out this unit. I want to register my unit and I need a statement number," and see if you get a response. But right now, they're only sending it out to properties, addresses where the mailing address is different.
So if one of these properties isn't registered because the city doesn't know that yet, and something happens with my tenant where there is an issue, are you saying when they go to court, the question's going to be, well, I need to see a copy of your registration? Like it's a hamster wheel. How do I get this copy?
Exactly. And the only thing that we would say is that a regulation cannot be impossible to perform. So if they haven't given me a registration number, I've already emailed them, they still haven't given me a registration number, then on that basis, you can't state that I'm not in compliance with the law. Also, there's a state law that says that if you're in substantial compliance with rent control statutes, that you cannot lose a case because of that. And on this basis, I think you are in substantial compliance. You can't do it. So they can't have it both ways.
And just one more question. When you do have the registration certificate, you said it has to be posted, but could you just have the tenant sign a copy that they've
You
signed and
can
acknowledge it?
for JCO, you can either post a copy or what you can do is mail it to the tenant. Either one is good.
Can it be an addendum to the lease?
Well, yeah, but you're going to have to do it every year, so that wouldn't make any sense.
Okay. Okay. Thank you.
Thank you. Okay. Harold Rhodes, how are you today, sir?
I am good. I am good. How are you?
I
Doing
am
good?
fine. And by the way, at 4 o'clock today, when this broadcast ends,
Yeah.
I am quickly exiting the building and heading down to crypto.com to see a game. So if
Oh, is
anybody
it
wants
they're playing the regular team's playing tonight? Okay.
yes, they are playing today.
Okay.
So if you're going to be watching the edited version, it's not going to be up until Sunday when I wake up tomorrow morning.
Would you
Go
ever
ahead,
watch?
go ahead with your question.
Just quick question. Do you ever watch the Sportsnet, the Lake Show that's constantly on?
Yeah, of course I do.
Of course.
As
And
you
you
can see,
watch the game again, right?
as you can see from the characters I got over my left shoulder,
Oh yeah.
we've got Kareem and Magic figurines.
We got to put a dentist figurine next. Okay, here's my question. Okay, up to 6 months, after 6 months, just cause. Now the tenant living there 6 months or more has these special, I don't know, rights or there's restrictions. But what if they're before that? Let's say if they're only there for 3 months and I want to evict them. Is everything the same or is there an advantage as far as getting the person out?
Okay, what kind of a property is this?
Oh yeah, single family residence, just cause LA with an
Okay,
L.
well, just cause doesn't apply for tenancies less than 6 months. Another
Right.
reason why you'd want to do a month-to-month tenancy. So if you wanted him out at the end of 3 months, for example, and he's on a month-to-month, you just serve a standard 30-day notice.
And if he doesn't leave, then there's nothing else. It's just basic lawsuit, not
Well, it's
wait 3
basic
months.
call Dennis Block.
But is it can you get him out faster because of
No, an eviction case is an eviction case, whether the guy committed a murder on the property and you're doing an eviction case, or if the guy merely didn't pay the rent. They all have the same, they're given priority under the law, but there's no gradations with regard to what type of an eviction.
Got it. Okay, thank you, Dennis.
Thank you, sir. Moving along to Arlene. How are you?
I'm good, Dennis. How are you? Thanks again, and good luck tonight at the game. I just have a quick question. I'm going in next week to do my semi-annual inspections. I typically get the tenants to sign off on after I have the preventative maintenance form. Do you suggest that, or is that detrimental to me?
No, sign off that the work was completed. That's all.
No,
Of
that we
course.
went through and everything looked okay, and then they sign, there's no deficiencies.
Exactly. I mean, that's contained in the rental agreement that the premises are perfect when you took them. Now, that doesn't mean that things can't break through no fault of the tenant, and then it's the landlord's obligation to take care of it.
Right. Just two things I just wanted to share with Margaret. If you go to LAHD to the website and go down to the bottom, there's a thing for capital improvements, and that's where you could the applications or forms are for you to use, and it takes a few months to hear from them. And with Pamela, I sent an email to get my certificate number, registration number, and they got back to me in about a week with a number.
Good information, Arlene. Thank you very much
Sure.
for spreading the
Sure.
information to the community, and I appreciate
Sure.
that.
Sure.
Moving along to Terry. Terry Munson, ask you to unmute yourself.
Hi, Dennis. I have a question. If I transferred title to an LLC, renting out my single-family residence, does that take me off Costa-Hawkins and put me on just cause and or rent stabilization?
Okay, this is a single family residence.
It is.
Only one house on the lot.
Yes, it is.
And this is in the city of Los Angeles.
Pasadena.
Oh, Pasadena.
Yes.
Well, if it's a single family residence, you're not subject to any rent limitations, period. I don't care what entity owns it. I don't care when they moved in. You're always entitled under the Costa-Hawkins Act to raise the rent to market level.
So having an LLC hold title and me being the manager of the property would not change its
No, now you still have to register with Pasadena. And if there's a tenant in possession, you do have to do a change of ownership because there's a change of ownership. Again, that form is on my website at evict123.com in the free form section.
I've been reading your website a lot. Thank you.
Thank you. Okay. Let's take a look here. We're going to move on to Rezo. I'm going to ask you to unmute yourself.
Hi, Dennis. I have two questions.
Yes.
Okay, so first question, my tenant on a triplex, SRO, they paid rent August last year with a money order, and I lost the money order. Agreed that they had the stub for the money order to get reimbursed and repay their rent. However, I've been struggling to get the payment for August, but they paid September and up to date. They're under market value.
Yeah, that's a tough issue because their position is, hey, I gave you a legal instrument and you lost it. You admit that you got it. If they were courteous, they would apply to the money order company for a lost instrument. They have the stub. You might be able to apply yourself as you were the payee. So I might try that. So your tenants obviously are refusing to apply for the lost
They
instrument.
did apply and they said they got the money, but they spent it. So
Oh.
they are admitted that they were able to get
Oh,
reimbursed.
great. So now you got a great case for eviction. What city is this?
Los Angeles.
Okay, how much is the rent per month?
It's under market, 50% below market.
I appreciate that answer. And now I'm going to ask you this question. How much is the rent per month?
It's 970 for a one bedroom.
970. Okay. So what I would do is I would not accept April's rent unless they pay you 2 months rent. Now, you're still going to be what they call below the threshold. I believe the threshold
Correct.
for a one bedroom is 2,086 without looking at my notes. So, but in May, they'll owe you 3 months rent. Now you can call our office and we can commence an eviction. So right now you have no obligation to take the rent for April unless they pay you the rent that they owed you. And they've already admitted that they got the money and they spent it. So that's a whole different ballgame. Now they owe you this money.
Okay. Thank you. And my second question is different unit. I did do a 10% rent increase for additional occupant about before COVID, about 6 years ago. Now they've informed me that the person has moved out. I asked them to let me know in writing, but is this in effect 30 days later? So for example, until May, or would it be the following month?
It would be the following month. So you increase the rent 10% for an extra occupant. Is that what you're saying?
Correct.
Okay, so once that occupant moves out and they inform you, then the next rent payment would be 10% less.
10% less what it is right now, or what I raised back then?
Whatever that that 10% rent increase was. So if the rent at that time was $100, $1,000, and you took off, you increased the rent by $100, I would just take off that $100.
Okay, that's all. Thank you.
All right, good questions. Okay, we're going to go back to, let's go to David. David's new. Let's take you.
Can you hear me?
Perfectly.
Okay. Hi, Dennis. Just a quick question. You know this the credit reporting law that comes into the effect. My question is, what happens? That may be a stupid question, but what happens if you just don't do it? What are the consequences of it? I mean,
I'm not sure what law you're referring to.
we talk about, I believe, 26 credit reporting, positive credit reporting that comes into effect on April 1st.
That's a good question. What if you don't do it? Is there any specific penalties? And the answer is that they didn't write any penalties into the law. Again, this is only for buildings with 15 or more units. Do you have a building like that?
Yes.
Well, look at you. Congratulations. But yeah, I don't know what the penalty is. They didn't
Why
state
can't they come later and sue you because I cannot get?
What are they going to sue you for? They're going to sue you for because their credit score would have been higher, and it's kind of
something like
a
that.
lawsuit that couldn't really ascertain damages. So, but hey, it's the law. I have an idea to do it. Okay.
Thank you so much.
Okay. And let's go to Daniela, second time around. Are you there, Daniela?
I am. Thank you. My luck, thanks. Under the new Social Security law, it requires that if we, as I understand it, that if we turn the tenant, the prospective tenant down, we have to refund their there's the screening fee. If in fact,
let me stop you there. That's not the law.
Okay, good.
If you gave the tenant the renter's requirement paperwork that told them what criteria you're seeking, you are allowed to take an application fee. If you take that application fee and the tenant doesn't meet your criteria, then you get to keep it. But you can't run two credit scores at the same time. Then even if the second person doesn't qualify, if you ran them both at the same time, as opposed to sequentially, then you have to give them back the application fee.
So we can, this is perfect. So we can take two people at one time, but if we turn one down, then we just have to refund the money.
Right, but the way to do it is you could take, 15 application fees and 15 applications, but run one application at a time. With the first one who meets your criteria, then you didn't run the other, so you could just give them back their checks.
Perfect. Thank you.
Thank you. And we're going to go back to Jim Polina. I'm going to ask you to unmute yourself. Wait a second. I don't think I did it right. Here we go. Jim, can you open up? There you go.
How's that? Not me?
Good.
Okay, great. Alrighty, well, I'm glad I can ask another question here. So 25 years ago, we bought a house, 3-bedroom, 2-bath house, and it came brand new with they call it a granny's unit. Okay. And we've always rented it out. Now I'm thinking, is that just another roommate I'm renting to? Because it has the same address, it's not an ADU.
Yeah, that's an illegal unit to rent out. It's a granny unit, but I would imagine that it doesn't have its own quote certificate of occupancy. And if it doesn't have a separate certificate of occupancy, then while residents of the main house can use that granny flat, so to speak, but it shouldn't be rented separately in most jurisdictions.
So this came, permitted by the county and by the builder, and the builder a brand new building. And you're saying it's not legal to rent it out separately
Well,
because of
I know in the Los Angeles area, it's certainly not legal, but you might want to check with the local municipality and building and safety of that area to see if it's permissible to rent that out.
Well, it came with a kitchenette.
That's
So,
nice.
oh,
Check to see
okay.
I would check with building and safety to see if it's legal to rent out.
Okay, so let's assume it is legal. So from an eviction attorney's viewpoint, is that a roommate I'm renting to?
Okay, no, because you're in a separate structure. A roommate is considered where they live in the same roof as you do, and they have a bedroom, but they also have use of the common kitchen and living room, etc.
Okay, I get it. All right, thank you.
All right, uh, let's move on to Angie. I'm going to ask you to unmute yourself.
Thank you.
Hello.
Hi, first time caller. Fairly new watching, thank you. So my question is about a fourplex that we purchased in 2005. One of the unit's original tenants, it's RSO in the city of Los Angeles. 2 tenants, a mother-daughter. Mother recently died in March. I think I spoke with you earlier about that. They're asking to add the son to the tenant, and you said no, not to add the son. So do we give him what is it called? It's
the son is moving in as a caretaker for the mother. Am I remembering this story?
so that's what she said, but when we gave her the caretaker form, then she said he's not her taker. She just wants to add him on the lease in place of her mother. But our
Okay, so
concern,
she does have the right in this is city of Los Angeles.
yes,
Okay, she does have the right to add another person. I wouldn't put them on the lease, but you do have the right to check his credit. And if he doesn't qualify, then you can reject him. But if he has reasonable credit, then you have to let him in as a replacement tenant under the auspices of the Los Angeles Housing Department.
Oh, okay. That's I wanted to clarify because I understood. I was a little confused after that. I thought we didn't have to add him. We would give her the opportunity to fill out the caretaker form, but it appears now that we do have to add him in place of the mother that passed away.
Right, but he's not added to the lease. He's just an occupant.
How does that work? I don't understand that part.
You're allowing them to have an occupant in, but you don't want to have a situation where she leaves or passes, and then now you have him as a tenant at the same rate as what she was paying. So you certainly don't want that. Anyway, thank you very much. We're going to end it here so I can castadle over to crypto.com to see my team. I want to thank everybody from coming out. We'll be doing this next Saturday at 3 p.m. I always appreciate the participation in the Zoom meeting, and you guys watching on YouTube Live, please hit that like button and subscribe to my channel. And with everybody, have a great weekend.